Step out of the car for me. And kick your hand up and step out of the car.
Man, what happened, man? What is going on? I need a reason, man. Hey, look, stop the car. I mean, man, y'all tripping, man.
Now stop.
Y'all tripping. I can't beat y'all. Call my mama, man. They just beat me up, y'all. The police just beat me up.
On April 2nd, 2024, a deputy initiated a traffic stop based on suspected illegal window tint. Under Florida Statute 316.2953, side windows must allow a minimum of 28% light transmittance. That threshold, when visibly exceeded, constitutes an equipment violation sufficient to establish probable cause under Terry v. Ohio.
What's going on, man?
How y'all doing? Can you roll this back window down? I can't see with this tent.
That window don't roll.
16. Step out of the car for me. And kick your hand up and step out of the car.
Man, what happened, man?
I've already asked you once when your hand's down there. I'm not going to sit there and ask you again.
My hand is nowhere, sir. What's going on? What? Y'all don't have proper cause to stop?
I do have proper cause.
What was the proper cause?
Don't be moving.
What was the proper cause? What happened?
Stop moving.
Sir, what is going on? I need a reason, man. I need a reason.
Well, since you're the
I'm in the back seat.
Since you're the driver, I'll tell you the reason.
I wasn't driving, sir. You can ask me I wasn't driving.
Step back.
I wasn't
Step out the car.
Stay away from
Man, you guys is doing the wrong thing. Hey, this is her car. Hey, look, stop the car. I mean, man, y'all tripping, man.
Now
y'all
stop.
Tripping. I can't be.
Stop.
Y'all tripping. I didn't even do nothing. I didn't even do nothing. I didn't do nothing, man. Man, come on, brother. Man, come on. Y'all call my mama, man. They just beat me up, y'all. The police just beat me up. I didn't even do nothing. Chris.
Where's 10-4? Give me a number.
Chris, hey, y'all, come on, man.
Just put him in your car. Stay in the car.
Stay in the car.
Man, come on.
Listen to me.
Come on, man.
Stop
I didn't do
playing.
nothing, man. Why y'all?
Stop playing.
I wasn't driving, bro. What is you doing, man? What is you doing? What is you doing, man? I'm not doing nothing. I don't have nothing in my pocket, man. What is you doing? Man, come on, man. No.
Stop.
Oh, man.
Stop moving.
No, y'all. Y'all call my mama. Call my mama, man. Call my mama. I didn't do nothing. Oh, my God. Oh, my God, man. No, brother. No, man.
Have a seat.
Man, what?
Have a seat.
Why, sir?
Get him away from that car.
Sir.
Get him away from that car.
Sir.
Have a seat.
Man, I can't. You got my dreads.
Pick your feet up.
Oh, man. I got a lawsuit right now for the police.
Pick your feet up.
Man, sir, why aren't you doing me like this?
Because you're doing this.
I'm not doing nothing.
Pick your feet up.
I'm not doing nothing, sir.
Slide your feet in.
I'm not doing nothing.
What's your name? Christopher, listen to me. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer for advice and agree with you during questioning. If you cannot afford a lawyer, one will be appointed for you without cost. If you decide to answer questions, your lawyer present, you have the right to stop answering any time. You understand your rights? Do you have any ID on you?
Yeah, it's in my pocket.
Okay, you got any weapons on you?
No.
Okay.
Car 211.
Can you grab it for me?
Car 211.
211. All right, ma'am. I need you off the phone and step out and talk to me, please.
I gotta step out and talk to the police.
216. You can slow anybody else down.
Hi.
Hang up
Or
the
any
phone.
other unit route to 216 can play your response.
What's your name?
Janice Henderson.
Okay. Do you have an ID?
Yeah.
Whose vehicle is this?
This is my friend's vehicle. I'm actually about to go get her from work.
So your friend's vehicle?
Yeah.
Who did she let use it?
Me.
Okay. Listen to me. I know who was driving. All right. Now I pulled you over because your window tint. Simple little window tint.
The window's tinted too
Okay.
much.
Who was driving? Because when I pulled over, y'all pulled in here, and y'all decided to switch cars, switch seats.
I stayed in my seat.
I know you did. Step back here. Who was driving the car when I pulled you guys behind you?
I was drinking her, and I'm not gonna lie. He was just with the way we acting like sober down. She was supposed to be driving, but
I know, but when you went through the light, stopped at this red light, and then you pulled into here, who was driving?
he was.
Okay. So I thought, would he tell you to switch seats or what?
I didn't know y'all was putting us up. He was like, "Can you drive? You feeling all right?" I was like, "I mean, I'm feeling all right. I'm drunk way earlier today, so."
265,
Okay.
signal 1 below,
All right, step back
area
there.
Warrington Elementary, 220 North Navy Boulevard. It's a gray Honda two-door. Was throwing things that complained it's a vehicle, had a golden retriever in it, white female driver. Last seen on Brandon Avenue. Can be clear at 1624.
They just searching through the car right now.
Because I got public costs too, man.
I know, I'm just letting her know because I had to pick her up from work, so I'm telling her.
Moments later, the suspect's mother showed up at the scene.
Yes, ma'am.
I'm Gloria. I'm the Say Rochelle's mom.
Okay. Hi, how are you?
I'm trying to figure out what's going on.
Well, he is under arrest. All right. So he's going to have a driving charge. It's okay. You need an ambulance?
I'm gonna tell you why I can't breathe, because last time my son got arrested, Officer Major, they put their hands on my child.
Yes, ma'am. I was there.
We have yet to deal with that bullshit. They don't have to do that. They didn't have to do that. So me even talking to y'all, excuse me if I'm a little hostile, okay? Me even talking to y'all, it's hard for me to talk to y'all because of what they did to my son.
I understand. So today he's just got a driving charge, and then he's got some more drug charges. All right, but he's, other than getting himself all worked up, he's not injured anyway or anything like that. He's just worked himself up to the point that he's yelling.
That's because y'all, I can say y'all have to understand why he's feeling the way that he's feeling. If it was one of your kids, if you suffered the hands of police brutality, misconduct, or whatever y'all want to call it, y'all will feel some type of way.
I get it.
I never in my life sat here and I used to be doing stuff like this, CO and stuff. I never in my life never thought that I would be the mother of a son that dealt with stuff like this before. I can't deal with this.
I got you. Well,
deal with this.
he was not, last time, I don't know what he told you, or if he was not unnecessarily just beat down in police brutality.
It should have never been hands touched. I read the police report, is what I'm saying. I read the police report, and the police report did not say he was resisting with violence. That was never on the police report.
He did not resist with violence. That is correct.
No, he shouldn't have ran, but that should have never happened. That's just a bad experience for me to deal with as a mother.
I get it, but unfortunately he's out here making the bad decisions.
He's grown, I can't stop that.
I know it.
But y'all trained to not put your hands on people, so that's what I'm saying. I can't.
Well, that's not
really
necessarily true, but.
Well, when it's necessary, do so. When it's not, don't.
I agree, 100%. So, but he's getting ready to get transported. He's not going to have a bond because he's still out on bond from the last charges, so he won't have a bond.
I kind of figured that.
Yep. So, but like I said, he's fine. He's just got himself worked up. So.
And that's pretty much based on what he done went through. I understand what you're saying. I understand. Chris, baby, you and that girl, I don't want y'all around me right now. Ain't even gonna lie. I don't want y'all around me.
So, is there any questions I can answer for you?
No, baby.
I'm not gonna let you.
I'm upset, but
I know.
I'm just.
I'm not gonna let you see him right now, because right now he's not yelling, and I don't want him to get worked up again seeing you.
He's not gonna get worked up seeing me.
I don't want that to happen, so to prevent that from happening, that's what I'm going to do. I'm not going to let you go over there and talk to him right now. We're going to get him out of here as quick as we can. We're going to get our stuff done as quick as we can.
Worked up me not talking to him.
Well, if that happens, then we'll deal with it. But we're going to get him to the jail as quick as we can. That way, we can get it done and get out of here.
Once the stop was initiated, exit commands were issued. Under Pennsylvania v. Mimms, officers may order the driver from the vehicle without additional justification. That authority extends to passengers under Maryland v. Wilson. Non-compliance with a lawful exit order is not a legal option. A seat switch occurred after the officer's lights activated a deliberate maneuver to displace a potentially impaired driver before the officer reached the window. John S. Henderson, the actual driver, later confirmed this voluntarily. As a non-custodial witness, no Miranda advisement was required. Under Miranda v. Arizona, the advisement applies only when a suspect is both in custody and subject to interrogation. Her statement is therefore admissible and constitutes direct evidence. of the seat switch the central factual dispute of this encounter. The subject's physical resistance to the exit commands produced a charge under Florida Statute 843.022, resisting an officer without violence. That statute requires only knowing and willful obstruction of an officer in the lawful execution of duty. No violent act is necessary. The vehicle search was conducted on probable cause. Under United States v. Ross, officers with probable cause may search the entire vehicle, including any containers within. The search yielded cocaine, a third-degree felony under Florida Statute 893.13, subsection 6A, and marijuana, below 20 grams, of first-degree misdemeanor. Under subsection 6B of the same statute, Miranda rights were read after physical restraint and before custodial questioning, the correct constitutional sequence. The advisement need not precede the arrest itself. 4 charges resulted: driving while license suspended under Florida Statute 322.0-3, possession of cocaine, possession of marijuana, and resisting without violence. Bond was denied. The subject remained on active bond from a prior case, a standard outcome under Florida Rule of Criminal Procedure 3.131.
What is I been arrested for, man?
Give me just 1 second and I'll tell you, okay?
Oh my God, man, I wasn't even driving. Why y'all doing me like this? Why y'all arresting me, man? Why y'all, Mom?
406.
Mom, hey, why?
1915 to the jail. Copy beginning.
Why is I being arrested, man? Please tell me, man.
895.
Man, please. Man, can you please tell me, man? Oh my God, man, you don't even want to tell. Man, why? I'm supposed to know why I'm getting arrested.
So, driving without a license.
I wasn't driving.
Possession of cocaine.
Possession of cocaine?
And marijuana.
I didn't have no marijuana on me, man.
The deputy receives a B. The stop was legally supported, Miranda timing was correct, and communication with the subject's mother was composed and transparent. The deduction. Probable cause for the vehicle search was not articulated on camera, a documentation gap that weakens the evidentiary record. The subject receives a C+. His denial of driving carries genuine legal weight and could affect the driving charge at trial. However, non-compliance with lawful exit commands directly produced the resisting charge. He also failed to invoke his Fifth Amendment right to silence, continuing to make statements throughout an encounter where silence would have served his legal position far better. Jan S. Henderson receives a C. Her voluntary admission confirmed the seat switch and simultaneously exposed herself to potential DUI liability while undermining the subject's primary defense. The right to remain silent exists precisely for situations like this one. 3 practical lessons. First, a lawful exit order does not require agreement. Disputing the stop through physical non-compliance creates criminal exposure that contesting the charges in court does not. Comply first, challenge later, through counsel. Second, the Fifth Amendment right to silence is a constitutional shield, not an admission of guilt. Invoke it. Voluntary statements made without counsel, in the middle of an active arrest, almost never help and frequently become evidence used against the speaker. Third, for law enforcement, on-camera articulation of probable cause is not procedural formality, it is evidentiary infrastructure. Stating the basis for a search clearly and on record protects the prosecution's case and the officer's own legal standing equally. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Audit the Court, for even more police interaction and courtroom content.